Case comes in, and all we have is the police report. Our guy, Abdul Ghafar Alhilo, and we'll talk more about the family later, was going, according to the police, 88 miles per hour on his motorcycle on a very, very busy, well-traveled city road where the speed limit was 35 or 40 miles per hour. And that's why Mark gave me the case, because it was just so good. 88 and a 40, what could go wrong? And the other driver, the defendant driver, took a left, and I got a video I'll show you guys here in a second just to kind of introduce it to you, but he took a left right in front of our guy who was speeding, and there was a big collision, and our guy passed away on the street in the arms of one of the eyewitnesses that went to go help. And the driver never even stopped, the Jeep never even stopped the vehicle, went for the collision, just kept driving, parked 3 blocks away, and then turned himself into the police essentially 3 days later. Not that day, not the next day, but the day later, and left behind alcohol and some marijuana in the car.
Like videos of the crash that might help people understand what happened and what the car looked like.
Let's take a look. Let's take a look. I'll introduce you to everybody here. Let's do it. I'm gonna share my screen. Away from current slide. All right, here we go. So you guys can see the Jeep there. That is the driver. And if you keep paying attention, that goes on loop, so you'll see it again. You'll see our driver approaching from the top of the screen in the motorcycle. Here we go.
Where's this video taken from?
It's from a local grease monkey, and there. Incredibly sad. And you see the Jeep keeps driving away. We have a longer video I'll show you guys later where you saw how you can kind of see him parking. But yeah, right there, our guy's head goes into the back of the passenger seat behind the driver, where someone's sitting, and kind of spears the driver, the passenger that's sitting there. And our guy's helmet falls in to the Jeep, and our guy falls back onto the road, and he passes away a few seconds later. And so there you have it. The guy driving the Jeep, let me introduce you to some people here, was Defendant Kleim. Daniel was from Germany. Him and his kind of off the boat. They'd been there in America about 8 years. This is his father, Jürgen, big CEO type executive, a multinational corporation. Think evildoer. That's how we painted him. This is the front seat passenger in Daniel's car. His name is Louis. It's this guy right here, Louis Delgado. So you had driver Daniel, passenger Louis, and then in the back behind Daniel was Mr. Shunk. And this is what he looked like in the hospital after the crash, after our client's helmet and head crashed into him, going what speed, we don't know. We know at one point it looked like he was going 88 miles per hour before he hit the brakes and tried to avoid the crash. And this is Michael Hernandez. So the driver of the vehicle, he left behind 7 beer bottles, a little shooter bottle of vodka. We'll show all that. And he spent the night at this guy's house, Michael Hernandez. None of these guys showed up at trial. Michael Hernandez, Louis Delgado, or Stephen Shunk. Couldn't even talk to 2 of them. He hid there that night while they were watching the news, the fatal crash, looking for a driver of the crash. And then he waited the next day, interviewed a lawyer, set up a bondsman, slept soundly that night. And on the 3rd day, interviewed a second lawyer, and then turned himself in on the 3rd day, the afternoon of the 3rd day. So, we got the case. I was like, well, yeah, our guy's going fast, but this is a drunk driver who left the scene of the crash with alcohol behind him. Who knows what he took with him? I think we can find a hook here. We can piss off enough jurors. They're going to be upset about it. And I think we should move forward, man, and go kick some ass on this thing. Oh, and let me show you our clients. Introduce you to all the players here. So our clients were from Iraq. They had literally fled the Saddam regime in the middle of the night and applied for asylum, I think, in Syria. And these were the Alhilos. Abdul Ghafar Alhilo. Ghafar is his nickname. Is the guy over here on the right. 9 brothers and sisters, very large families. Dad had passed away. Salt of the earth, wonderful people. I literally just got a text from Salam, this guy, on Easter, wishing me a happy Easter. We got a chance to meet these folks and go to their house during Ramadan. They fed us. I mean, just wonderful people. And this is, you can't see it with the exhibit bait stamp here, but this is mom, Naima. That's your plaintiff in Colorado, the wrongful death survivor. Abdul, Ghafar, guy in the middle. He had no wife, no kids. He was 25. That's our favorite picture of him, smiling with his two sisters. And so Naima was our plaintiff who spoke no English. And although you see her here in, pretty standard outfit, she's got the hijab, but she's got a nice little red shirt on. By the time we get to trial, she's just wearing all black. She's in mourning for 4 years because she doesn't want her son to see her from heaven and see that she's wearing color and think that she's happy. So she continues to mourn well past the 60-day traditional mourning period in the Islamic faith. So, we met our folks, we met our clients, and then we're like, okay, well, can we win? Is it possible? And so,
one other thing on that point, Kurt, that at that particular summer that we took the case on, Colorado Denver in particular, was having a ton of very high profile hit and run cases. And so there was, the alcohol piece and the drug piece, which we'll get to, which is always kind of there in the foreground of many of these cases. We also just had kind of a hot media situation. So there was a little bit of an opportunity there as well.
Yeah, we always envisioned getting on the front page of the Post with our big trial victory. Turned out to happen. So that was kind of a cool dream come true. But there were a lot of challenges. Colorado does not have great laws for some of this stuff for those of our non-Colorado viewers. So we are a 50-50 comparative fault state. So if our driver going 88 miles per hour was 50% at fault or more, case is over. We lose. There's no you get 20% of the damages. 50-50, you're out. So you got that. You've got a damage cap in Colorado, $436,000 for the pain and suffering and wrongful death. That's the most someone, according to the legislature, could grieve and have pain and mourning. Now, there's a way around that in Colorado. If you can have the judge rule after the trial that the killing was the result of a felony called felonious killing. So in this case, vehicular homicide. If the judge agreed it was a felonious killing, then we could bust the cap and the cap goes away. And we had a real chance to do this here, and we failed at that, unfortunately. We were all ready for it, the briefing, and that's one of our lessons. This was 2014. So a lot's happened since then. Hopefully we're getting a little better at arguing damages, but this one was not our best in terms of money. We'll get to that in a little bit. And this was also during the time of, if you all remember, when ISIS in Syria and Iraq was really big, and there was a lot of media demonizing that part of the world, and probably rightfully demonizing ISIS, but then everyone else is getting lumped into it. And there's a lot of anti-Islamic sentiment back then, much different the world than we have today in 2021, I would think. So we had that going with us, or going against us. Mark, what are some of the challenges we had in this case? To kind of give overview. We got the 50-50 bar. Guy was going 88 miles per hour on a 40 mile per hour road.
One of the biggest challenges was just the complete lack of interest and cooperation from the Denver police. They had an opportunity, really. This guy's a really bad actor, which Kurt will get into. And I think a lot of circumstantial evidence that really should have motivated them to charge this person for a DUI causing death, or at least a DUI. And they basically let the guy skate. And then when it came time for us to, kind of showing the police, how bad this guy is. This is a guy that ran away from a death scene and hid for 3 days and all kinds of other bad facts. They continue to just thwart our client's case all the way through. We'll get to that, but the police never, ever put any blame on Kleim, the driver of the SUV, for anything in this case. So it's very difficult to go in front of a jury and hear anything other than your client was at fault, or the client's son was at fault.
Did they charge Kleim with leaving the scene of an injury accident causing death?
Yes.
They did. And he violated his parole or probation by testing positive for cocaine during his probationary period. Did that come into trial? No. Did it come in during our briefing for motion for punitive damages to make him look like a really bad guy? Absolutely. So, you had to work with what we had. Making things more difficult on the liability side, adding what Mark said, is that our guy had no license. He was a licenseless driver, and he was what's called a habitual traffic offender in Colorado. What that is if you have 3 serious offenses, then you lose your license for 5 years and you're a bad person, you're a habitual traffic offender. And the case law on that was not clear that doesn't come in. So we're terrified of that fact coming in. We were able to keep it out through some good brief writing. Mark said the police testified against us. That was not fun. We couldn't talk to those other people. There was a question in the chat, how do we get photos of them? Well, one of the photos, we had security surveying them because they wouldn't talk to us, trying to find out where everybody is. So some of those are security photos. The other was turned over in discovery of the bloody guy. That's how we got that one. And we never got to talk to them. We got to talk to the guy in the front seat. We'll talk about him, Luis Delgado. We got to talk to him, but not the guy who was injured and not the guy whose house they went to, because they kind of hid where they were. And I think the guy who was bloody, I think he never really recovered from his brain injury, sadly. So I don't think he was ever in any capacity to really talk. So, I mean, sad case all around. So that's what we got the pictures. How do we fail on damages? We'll talk about that. There's another question in the chat.
Yeah, but make sure whoever's got questions, they put them in the Q&A. Which
that's where I'm reading them from. I'm sorry, the Q&A.
Let's say Q&A, because people are supposed to put them there, and they're doing a great job of it. Yet you're not acknowledging it, Zaner. I mean, come on, you got to encourage.
Great job, guys. Andrew and H. Lee. Yeah, you guys are in the right spot. You're where you need to be.
All right.
What else can I tell you? And so as we don't have a blood alcohol content. I mean, we're building a DUI case without any DUI evidence. We have no BAC. We have nothing because he was gone for 3 days, and that was by design. Him and his dad looked on the computer to see how long they could stay away and not have alcohol in the system. So, and also there was a DNA specialist, and the driver's DNA was not on the beer bottles, and it was inconclusive whether his DNA was on the marijuana. So we didn't know how that was going to play out. That was challenging. And then you look at the damages, it's an individual defendant, it's Mr. Kleim, it's a 25-year-old kid. We had dad as a defendant as well, as part of the family car doctrine and a negligent entrustment claims. We had both of them, but it's not Coca-Cola. So people probably feel bad about rewarding millions of dollars against person. In Colorado, you can't talk about car insurance, probably like most other places. So they don't know that American Family was involved. And so you got that challenge, you got the wrongful death cap. There's no wage law. There's no economic loss here. No wage loss, no dependence really, because he wasn't supporting his mother. And so looking at a damage perspective, all you have is that cap, that 450 we can go for or try and bust it. But that was also challenging because mom, client, did not want us to ask for money. Very, very devout folks. And they believe that Ghafar was looking down from heaven and was watching. And they didn't want to have me ask for a dollar amount or Mark ask for a dollar amount because that would be like trading his life for an amount of money. And that was very sacrilegious. They were very adamant against that. So, we tried to be creative in talking about money, but I couldn't ask for an amount. I couldn't tell the jury what to provide. And yes, Lee, you do get non-economic damages. That was our only claim. The pain and suffering non-economic damage cap in Colorado is that 450. That's all we could really get. I mean, the jury doesn't know about that. But
Kurt, real quick on just challenges. I mean, just so everybody gets a sense of this, because you may not be in Denver, but this road that this crash happened on, their client was traveling allegedly close to 90 miles an hour on, plus or minus five miles an hour, is a very busy, very well-known street in West Denver called Federal Boulevard. It's where the Broncos Stadium is. It's kind of famous for ethnic food. It's got just a lot of traffic all the time. It's a busy thoroughfare. So the idea of somebody going that fast, I mean, I still have an uncle that's mad that we won because because Mr. Alhilo was going 90 miles an hour on a motorcycle on that street, which is 35 or 40 miles an hour, depending where you're at, just really, really busy. So, I mean, our own expert testified, we'll get to that. I don't want to lay out everything, but he said it was the fastest motorcycle he had ever seen. This is our expert, the fastest motorcycle he had ever seen in a reconstruction on a city street. And so just the sheer science behind the human factors of whether somebody could perceive it, closing distance, et cetera, was really difficult to overcome.
All right,
go ahead, Dan.
You guys do any focus groups on this case?
We did not. We haven't done a lot of focus groups. I think, we were talking in our prep session and Mark brought it up at our attorney roundtable yesterday. We need to start doing more focus groups. For a long time, I wasn't a believer in them. and we didn't, and you know, they're expensive, and you know, young firm, there were just the two of us. We had one more lawyer, I think, at the time. So, you know, we're careful and pouring all this money into a loser case. And I was like, you know what? I don't think it would change how I would present anything, given that we only were awarded $750,000 for mom's pain and suffering. Maybe we should have a focus group. Might have been helpful to figure out some better ways to argue damages. So we didn't. Mark's done focus groups before this. Do you have any reason why we didn't do it other than me saying no?
I mean, I think, you know, it was, you know, early stages of the firm. I mean, we had thrown a lot of money at the case. It was probably a mistake. You know, we probably could have learned something from it. I think probably a little bit of our ego at the time, and just being overwhelmed with trying to get the firm off the ground. We're pretty young. I think we were first year, second year into the firm. So probably a lot of that. I mean, this is 8 or 9 years ago we were prepping.
7 years ago, more specifically, Mark.
Well, that verdict, but it got continued a couple of times. So we probably could have done one, you know. I mean, I think the crash happened in 11. We got the case in 12. So, you know, I mean, 9 years ago, we probably should have, you know, theoretically done one now. We probably would now.
So they offered us, I think there were a lot of debates about how this damage cap worked. And defense counsel was saying, well, no matter, you applied that damage cap first 450, and that's the most. And then you do comparative fault and you take away from that. So if your guy is 40% at fault, the most we're going to owe you is like, you know, 170. So here's a $150,000 offer. And that was how the defense bar was interpreting this comparative fault statute. Luckily, we got the Court of Appeals to clarify that in this case, and he's now officially wrong. And the law in Colorado is you don't apply the cap first. If it's $1 million verdict, if you first apply the comparative fault, 40%, you'd knock down 400 grand. So the result will be 600, and then you apply the cap. So they offered us shit money on it. And 2 days before trial, so we had claims against dad and for this family car doctrine and against son. And we decided to dismiss dad, and then they gave us $50,000 for it because we didn't want to have, we wanted one big villain, and we didn't want to have any sympathy for any parents out there where this guy could get tagged, dad could get tagged for millions because his kid screwed up. You know, I think that was Mark's idea. It's just, he thought, you know, juice not worth the squeeze there. You know, the cons outweigh the pros. So let's get rid of him. And so we got rid of him on the eve of trial. And the offer still stood, I think, at 150. Mark was like, why don't you try and get the 250? Maybe this Hart's case is really bad. Why don't we just try and get it? And my response to Mark was my classic, you know, Han Solo. Never tell me the odds. Never tell me the odds.
Classic.
Yeah, I mean, we did try. We tried to get it. I mean, we had to set the hook for for getting the insurance company to buy the verdict beyond the policy. So we did send the appropriate letters that demanded the limits, but it was clear they weren't going to pay it. The limits were 250. There was a question on the Q&A about damages for survivor non-economic damages. At the time, they were at about $430,000 in Colorado for a cap for non-economic damages for a survivor action.
So we know of all these challenges. You guys worked it up. So what were the motions eliminated that you guys filed and that the defense filed, and how did the judge rule on them, and how did that shape your case? Yeah,
no, great question. And so Mark and I dove in, and we got real quick on the demand thing. It's obviously, I think it's an important point. I think this is also the first verdict in Colorado where an insurance company bonded, and for the appellate court, and paid punitive damages. There's even a case on point in Colorado that insurance companies don't have to pay punitive damages. But we demanded that policy right after we deposed the defendant. They said no, and that was enough of a hook to get the insurance company on. Because like I said, look, pay us your 250, or I'm typing right now, or we're gonna get punitive damages, and we're gonna get a big verdict for millions of dollars on the front page of the Denver Post. And all those things came true. And so they had to bond the whole appeal, which was cool. And it didn't always look that good though. It was obviously daunting. But all right, so here, how do we get in what we need to get in? The motions limines were huge, and I want to include in MILs the motion for punitive damages, because this was the only way that we thought that we could win the case, is by filing a motion for exemplary damages in Colorado, because we have all this behavior of the defendant. We've got him. I've told you the best parts yet. So he was 25 years old at the time, and he had 2 prior DUIs. He had a .05 when he was like 19, underage, and then a .16 when he was 23. And so he's 25 now at the time of the crash. he's got these 2 prior DUIs. And gosh, it sure would be nice if we could get those 2 prior DUIs in. But how do you do that? 404B evidence. There's no case law in Colorado that you can get in prior DUIs for purposes in a DUI case. Now, we also don't have a DUI case because there's no evidence, no direct evidence. We became big fans of circumstantial evidence in this case, that he was drunk, right? Because there was no BAC and he had fled. So we needed a punitive damage motion to get in the prior DUIs, to get in, building on the premise that he was drunk. We still have to prove that he was drunk, because it's not like a typical DUI punitive damage case where the guy's got a 0.10 BAC. We got to prove he's drunk. And then we really, really want all that behavior after the crash. So to recap that again, he parks 3 blocks away. He's got his bloody friend in his back, and the friend next to him. He gets out of the car. Who knows what he took with him? We know what he left behind. And he ran 17 miles by his own account with 2 broken ribs, and then hung out at his friend's house that night, fell asleep at 1:30, called his parents the next day, interviewed a lawyer, interviewed a bondsman, went to bed that night, woke up the 3rd day, interviewed another lawyer, and then had the bond set, and then turned himself in at 3:30. And why did he do that? Well, our argument was that he did that because he was trying to avoid vehicular homicide charges or HTO charges, habitual traffic offender. Because the only way we could prove that that was his motive was, so it's kind of a motive argument. He fled the scene to avoid getting caught and getting charged with these really awful things. But he only knows about these awful charges because of his 2 prior DUIs. Because in Colorado, when you get a DUI, much like other places, you have to do all this alcohol and education classes and therapy. And so that was our way to bring in the prior DUIs to show how he had learned what the consequences were for getting hit with, or for hitting someone while being intoxicated. And so that was one of our arguments. And then we also said, well, also, Your Honor, everything. So let me show you guys a few standards here. I think this will be helpful. Let me pull up. It's a little bit of text. I hate sharing text on these kinds of things, but I think it is helpful. Motion for statutes, and here we go. So slideshow from current slide. So winning in a page and a half. I give this other CLE sometimes about writing. I love writing. Trying cases is great, but we don't get to do it often enough. Writing, Zaner Harden law, we've developed this theory of how to write really good legal briefs. And I know this is about the whole case, but I want to just sidetrack for a few minutes on it, because I think it's really important. Because if we didn't win this brief, we wouldn't have had all the evidence we needed to get in, and we would have completely lost the case. Because the jury would have just been left with who was negligent at the time of the crash, which we 100% lose 10 out of 10 times. Unless we get the post-accident behavior in and the prior DUIs in, I don't think we win. I don't think we've talked about the result yet, but the split at the end was 45% comparative fault to us, 55% to the defendant. So we just by 5%, skin of our teeth, won this thing. Without those 2 after and before pieces of evidence, there's no way we get anywhere close to that. So we have this theory of brief writing where your first page and a half in any brief, especially a motion for punitive damages, is just a story. There's no case law. There's no legal writing. You just rope that reader in by telling a really objective, passionate, persuasive 2 pages of what happened. So when that reader, and I say reader because I clerked for a federal judge, and the federal judges don't usually read the first page, the brief. It's usually the clerks. So you want that reader to get to the final, your little story, and then think to themselves, this is really unjust. What happened? I want to find a way to help this person. And that's what the rest of your motion is all about. Providing the case law and the arguments in order to arm that reader, that clerk, to find a way to rule in your favor. And so this is like the first case we did this big page and a half thing in, and I think it worked out really well. And we argued in it that, well, let me show you the standard. I think it's important. That's what I wanted to show you guys. Let me share screen. Share there, slideshow, play current slide. So we want to get all the evidence of him being drunk in, and alcohol and drugs in the car, and him fleeing the scene and the prior DUIs, all of which we knew would be motions in limine to preclude. I think that was one of the questions in the Q&A. So what do I want to go through here? I mean, first we had to show that he was drunk, because we don't show that there's prima facie evidence he was drunk. How do we get all the other stuff to say that, well, there should be punitive damages because he drank and drove again? Well, we got to at least first show he was drinking and driving. So we took all the different kind of bad driving behavior that we could find and threw it in there. And then we talked about his motive. His dad says, if he got a third DUI, he could become a habitual traffic offender and lose his license for 5 years. And so showing the motive of why he would flee the scene and avoid getting charged. And then here, where do I want to go with this? I want to show you the standard for punitive damages. Willful and wanton conduct. Here we go. Share screen. So in Colorado, you need to show willful and wanton conduct. And it means an act or omission purposely committed. It has to be consciously, purposely committed by a person who must have realized that the conduct, drinking and driving, was dangerous, and which conduct was done heedlessly and recklessly without regard to the rights and safety of others, particularly the plaintiff. All right, so we got to show a couple of things. He purposely drank and drove, knowing that what he did was dangerous, and particularly dangerous to the people that are on the road. And so in our motion for punitive damages and in our argument, it was like, Judge, listen, he took 48 hours of drug and alcohol education classes where he learned just how dangerous it is, all the ways that alcohol and marijuana impair your ability to drive, reduced judgment, the ability to observe speeds, all these things. And also you take what's called, Dan knows this, he used to do criminal defense law, victim impact panels when you get DUIs. What are those, Dan?
Where you guys sit around and listen to people's lives who've been destroyed by drunk drivers. So maybe it drives home the fact that your decision to drink and drive maybe wasn't the most considerate thing to do in the world because you have destroyed other people's lives.
That's right. He went through 2 of these. So our argument was his decision to drink and drive was so willful and wanton because he, unlike Joe Schmo on the street who never got a DUI, he knows firsthand how dangerous it is and how it can destroy people's lives. So, Judge, all of his priors are absolutely relevant, not to whether he was negligent at the time, but whether to his degree of how willful and wanton it was for him to get behind the car and drink and drive for a 3rd time. And the judge agreed. And now in Colorado, we've got Court of Appeals case law because of this case that you can bring in prior DUIs for purposes of exemplary damages. So hopefully everyone can replicate that across the country and keep feeding that case law and keep creating it everywhere because it's obviously incredibly helpful. So I was going to show you guys. All right, so that we won the motion for punitive damages, and so the court didn't rule on this until right before trial, and so we had our motion for punitive damages pending, and then they filed their motions in limine. And their motions in limine were what you would expect. Exclude all mention of alcohol, exclude prior DUIs, and exclude mention of the defendant leaving the scene. And so because we'd already briefed that months ago, you know, with all the evidence, and I'm happy, I don't know if it's, I think it's part of the file we shared, Dan, the briefing on that. It's a lot of fun. We really enjoyed it. Did you read it, Dan? Did you read the, probably not.
All last night, it's all I did was sit and read every motion and brief you filed on this thing, so I'd be prepared for today. Are you kidding me?
So
I think I'm learning to become great like you guys unless I read all of your stuff. It's not going to happen.
Putting the work in. So the judge ruled against all of them. He said, well, look, all this stuff is relevant for exemplary damages. So all their motions in limine were denied. Now the cocaine thing, we didn't even try and bring it in. Maybe I did. I think I got shot down at trial. I was reading the transcripts again last night. But the page and a half, going back to the brief writing for a brief second, when you're writing these things, like, remember, there's no rules of evidence. Like, all you're trying to do is sway the reader to want to help your client.